everyone, and welcome to the Society of Construction Law podcast. We're here recording at the Society of Construction Law Conference on the Gold Coast. It's been a fantastic conference, and we're going to have an interview between Alisa Taylor from Meyer Vandenberg Lawyers in Canberra and from Ian Bailey, a barrister in Sydney. We're going to talk about a subject that Ian is incredibly passionate about, the difficulties we face with respect to private certification and consequent non-compliant issues you can have with multi-storey buildings. Just how big is this problem? How widespread is this problem? And how do you tackle a problem that's this big, that's got this many participants, that may need political change? I'll hand it over to Alisa and Ian to have a chat.
To understand the problem, we should go back to the beginning and where the problem arose. Prior to the early 1990s, there were a number of cases where local government authorities were found liable for failing to inspect and issuing compliance certificates and completion of buildings. And the local government associations and local government in generally got sick and tired of being the last man standing, or the last uninsured party standing, and they persuaded the government to introduce some legislation. And in the early 1990s, there was a document called the Building Bill, the Uniform Building Bill, and it included a number of reforms, theoretically. One of them was primarily to allow for private certification by building practitioners who were approved under some sort of scheme. But the other thing that's a big problem is they also introduced, to satisfy the professional indemnity insurers, they introduced a scheme of proportionate liability, which now has its ramifications in multi-party proceedings, and the process has deteriorated very seriously primarily in multi-storey apartment buildings, where we have it's more a combination of fire and waterproofing problems, and they are just in really quite serious problems, particularly, if I could put it this way, at the third and fourth level of tiers of developers. I don't think Dent Lend Lease or Mirvac would have these problems, and in fact we know that some of the major contractors, recognising the fact that they don't have proper training, are actually setting up training camps in big buildings so that they can have their project managers learn about how to do waterproofing properly and these sorts of things. But the big issue is, how do we fix it? That's the big question.
Yeah, and I think that you're right in saying that the bigger builders and the bigger developers don't tend to have the problem because they have more of a reputation at stake, and they really want to make sure that their name is held in good standing going forward, and also they've got the resources.
Yeah, and by contrast, if you look at what I rather crudely describe as the Mahaja, or the typical really bad developers approach, they will have a development consent, they'll have an architect design to make some pretty drawings, they will then sign a design and construct contract with a contractor who will be pretty heavily screwed, or priced right down to the bottom of the market. They will appoint a private certifier appointed by the developer who will certify satisfactory completion based on all of the paper, which is nonsense. And the usual scenario is that the developer corporation has a fight with the contractor towards the end and doesn't pay the last couple of million, takes over the contract, completes the work whilst the litigation is going on with the contractor, and then the certifier issues an occupation certificate, strata plans registered, developer goes into liquidation, and the owners of the units have no relief against anybody. There's no insurance for anything above 8 stories, and there's just no relief. And the most recent example of this is in the North Shore Times recently, where the Ku-ring-gai Council had directed the owners corporation of a home unit in up in the North Shore, Warrawee, to actually give them 18 months to take off all of the aluminium cladding from the outside of their building. It's going to cost them hundreds and hundreds of thousands of dollars. But that's the sort of thing that I'm focused on.
Yeah, and owners' corporations really are getting squeezed in the middle of the sandwich because they've got obligations down to the unit owners to maintain the premises, and waterproofing can be a real problem because if there's a waterproofing defect, then the water will have some ingress into the premises, and then the unit owners might have a claim against the owners' corporation
for not
maintaining the premises.
Yeah, it's I think that with the really bad developers, though, and I can give you one example that we now understand that if the developer sells only a proportion of the units, they maintain ownership and they can maintain control of the body corporate.
Absolutely. We've actually run a case in the ACT recently behind the scenes where an owners corporation had that exact same problem. The developer owned 53% and was preventing them from doing certain things. And we actually managed to get a decision about oppression of minority unit owners in relation to that situation. But it's really tough for them.
Well, when you've got to go to that sort of length to try and get a legal remedy, it's quite
It's amazing,
hideous. Yeah. I've heard of circumstances, and I won't defame them by putting their name on the podcast, but a well-known developer who is not known for quality, they will retain up to 30% of the units. They will sell 25%, and a management company will take the body corporate votes from the foreign owners, and nothing will ever change. And what I heard about is that some foreign students were tenants in this place. The water from the bathroom in the unit next door flowed under the wall, and the students, to be able to live in it, would put pallets down and then past
living on piers in their own apartment.
MDF on top of it, and then put the carpet back on top, and then just put heaters under to try and dry it out. Now, there's no body corporate that's got any interest in fixing it, and that they're only tenants and they're paying nearly nothing, and it's really quite scary. The issue, I think, has been really highlighted because of the tragedies in London, which Matthew spoke passionately about. It was wonderful to hear.
Fantastic speech this morning, presentation.
It was wonderful, and that's what we expect. Yeah. But the big issue now, I think, is that we've got to get unified approach across the country. Now, the Senate inquiry is about to conclude, and we'll probably make recommendations. The big problem that I face in New South Wales is that the government in New South Wales received a report from Michael Lambert in 2013, which had a huge series of recommendations, primarily to set up a building regulation advisory council of industry representatives, and that hasn't even been done. And one of the primary objectives was to try and bring building regulation, take it out of planning, take it out of fair trading, actually call it not necessarily a new department of building, but a building regulation agency that dealt with discipline, dealt with regulations, enforcing and taking over penalty actions. But the government has not accepted or adopted those recommendations. They decided to adopt 270 out of 720, and it's just not getting anywhere. And so I'm pleased that Socklers decided to take on this battle nationally, because it is a national battle. It does make you really sad when you think about what Federation has done for the legislation and regulation in this country.
Yeah, it makes it very difficult for anyone who's in the industry to know what they need to do and how to do it. And it makes it difficult for decisions to get made.
Yeah, and for people in industry to move from one state to another when security of payments are a big enough problem, but why do we have to have different
entirely different regimes? Yeah, it's a huge problem for my clients in the ACT because they all work in cross-jurisdictional in a cross-jurisdictional way.
Yeah.
and they have to learn 2 sets of laws. And Matthew gave a great example this morning of how big those laws actually are when he compared the volumes, the pieces of paper in, was it the Victorian legislation?
Yeah, the building regulation.
Said that it would be higher than the Eureka Tower in
That's
Victoria.
stacked vertically with the pages. That's extraordinary.
Yeah.
But, well, I think the good thing is that we at least have a number of solutions that we are pushing. One is that I've indicated to the state government, New South Wales, it is the developers who make the money in strata corporation buildings. They should have a statutory obligation to ensure compliance. Now, however they do that, by employing architects and engineers, and one of the things that could be simply said is the principal things such as fire, waterproofing, and major elements in the structure should be certified by the designer, being compliant design, and also certified on completion. And that's a sensible way of incorporating the existing process. And it means that the developer's just got to pay for getting it done properly. And that's one way. And the other was the very interesting thing that Bruce Morrow spoke about, the decennial system that applies in Europe, and that's something that we certainly at SCL can consider whether that's another recommendation we make.
Yeah, I was fascinated by that part of his talk this morning, particularly his estimation of how much it actually cost. And the percentage he gave, I think, was 1.5% of construction costs, which I'd always thought the rationale for not insuring against defects was that it would be a prohibitively high cost.
Yeah, what they've found is that by a combination of processes, one is the legislated requirement for residential buildings to have the decennial insurance. That is, you've got an insurance policy that lasts for 10 years. The other is that...
And this is different to the homeowner's warranty, because it's not just a safety net for insolvency, it's actually an insurance policy against defects,
that's right, for 10 years. And because the insurers have a real interest in not paying out, the insurers are the ones who enforce compliance. They carry out inspections, they have training programs to make sure the industry understands what's required. And it simply works. They don't have in Paris or in Germany and Belgium and other countries where they've adopted this system, they don't have the problem. So maybe that's something we'll be able to look at in SCL when we...
I found that a very interesting part of this morning's discussion.
Very interesting. I wondered where he was going, but eventually he got to this decennial thing. And let me tell you that this was quite interesting, that Philip Britton, Professor Britton from King's College London, teaches this subject on building regulation in domestic situations around the world at Melbourne University. And I was in London introduced to a set of chambers in London, and he said, well, you must come along to this conference, and I want you to sit down and listen to it all, and at the end of the day I want you to just bring it all together. It was quite remarkable to hear how the decennial system works in Europe, but also the system that they have in England. They only have about 26% of defects of any significance in residential building. There's a big problem currently, though, with developers who are selling defective buildings and financing the sale, and the poor purchasers have very little remedies. And if you read the Times, there's quite a bit of news about that. But they don't have the problems like we have.
I think the statistic this morning was that 80% of our buildings are being handed over in a defective state.
Absolutely, and they're the statistics that came from Michael Lambert's report. 86% of home unit buildings, high-rise, have defects. 29% of them have major defects in fire and waterproofing.
Wow.
Yeah.
It's terrifying.
It's terrifying. You wouldn't want to buy a unit in New South Wales. That's and that's the campaign we've been running, is to say to the government, Lambert or lose. You adopt the Lambert report or New South Wales loses.
Yeah, and that really goes against housing affordability as well, because if people they don't have confidence in buying apartments, they're forced into a different product, but they don't have the affordability to buy that product.
And what we suffer is the potential that if foreign owners are renting out units which they don't wish or care to fix, we're going to end up with acres and acres of slums. It's pretty sad. Green Park is a part of Sydney that I would seriously recommend nobody go anywhere near. But there was a program on ABC Radio National on Big Issue, looking at the waterproofing problems at Breakfast Point, the units at Breakfast Point. Again, the same issue about the developers disappearing, phoenixing, all of these other issues. So it's a phenomenally complex problem, but it has to be addressed nationally, I think.
Yeah, I think you're right.
Yeah.
You mentioned fire rating a minute ago, and one of the things we should probably talk about is the Grenfell Tower disaster, and the implications for what's going on in Australia. I mean, everyone's having inquiries now into the products that are out there, but my view is that this is maybe a sleeping dog, and I can talk from personal experience of having lived and worked in the ACT, where we've just gone through the Mr. Fluffy asbestos, whatever you want to call that,
disaster,
debacle. Really, yeah, it's cost the federal government $1 billion to fund ACT government to demolish these houses and pull this product out. That's not a building product that was put in at the stage of building, but I can see a similar thing happening with defective products that have been used for years and years and are now just coming to light as being unsafe.
Yes. Karen Stiles, who anybody who reads the Sydney Morning Herald or listens to the Senate reports on the Senate inquiry, she's the head of the Owners Corporation group, and she's absolutely amazing woman and very good person to have in our group. And she has a block of units that cost $8 million to build, and it's going to cost $3.6 million for the owners to fix it.
That's amazing.
You've got to actually have a loose $250,000 for a one-bedroom unit on top of what you paid for it. And the problem is quite large.
Yeah, and then once those things come to light, the unit is unsellable.
That's
so
right.
You're stuck with an investment that not only lost you money, but actually is costing you a lot more money because you're required to go and fund these things.
And that's why I think if only the government could understand this is an economic issue, apart from being public policy, it's an economic question. And we're not going to solve the affordable housing issue by just building slums and letting people live in decrepit buildings, but it's a very interesting and complex problem, and it's really good that SOCLA's taking it on.
So for the rest of the day, Ian, what are you really looking forward to seeing as part of the conference program?
The Brookings Prize.
It's always a highlight.
It is extremely, and I was talking to His Honour last night, and I'd said to him that I hope you realise that you may not be around forever, but your name will be attached to what's become an internationally recognised student paper. And when you look at the candidates that we had for the Brookings Prize, they came from all over the world. There were people, and people are lining up to want to get into the competition. It's quite phenomenal. Matthew's done a brilliant job, but it's nice that what will happen is that the students will be the winners will be given a chance to speak briefly about their papers and receive their prizes from His Honour.
Yeah, it's fascinating.
Yeah.
And, as a past recipient of the Student Brookings Prize, I have to say that the calibre of the papers that go in are just outstanding.
Absolutely, I remember your paper. But what do you particularly enjoyed so far?
I really enjoyed the futurist discussions this morning about the Hyperloop and also about the self-driving vehicles.
Disgusting. A car that doesn't make any noise is not... It should not be allowed to be anywhere near the streets. Anyway, I'm sorry, that's a personal view. But I agree with you. I think that was, and the committee's done a fantastic job of looking forward in so many different respects. I mean, Bruce Morrow's paper, although he took a long time to get to his solution, was pointing out that we really do have to do something. He was good.
Yeah.
Now I'm looking forward to something else this afternoon apart from Brookings.
Well, I'm really looking forward to. I mean, the future is really a big focus of this year's conference, and I'm really looking forward to seeing some of the talks about machines, artificial intelligence, and the disruptive client. Society of Construction Lawyers running some really interesting debates with the Young Constructor Committee around the country at the moment about apps and whether apps can fix the world.
Right.
I think there's a really interesting issue, and I'm looking forward to that session this afternoon.
Yeah, and the rise of the machines, because Jenny Baker and Alisa, it's another different way of spelling a similar name.
She's got it wrong.
But I'm looking forward to that, and they're just, it's wonderful. I've had a little bit of dealing with them at Vincent Mason's, and I'm looking forward to that. The disruptive client might be interesting.
Yeah, that's probably my top one for this afternoon. I'm really interested to see that.
I had a client a few years ago who he was a Boston, a Jewish man who was a property developer, and he had this very thick accent, and he said, "Mr. Bailey, I want blood. I want blood." And I said, I won't say his name, but I said, "Look, you just give me money, I'll give you blood." There you go. He wasn't really a disruptive client, but we settled the case very successfully for him eventually.
Hopefully no blood was actually spilled in the making of that case.
Yeah, no. A lot of time was wasted, that was all. All right.
Thank you so much, Ian. It's been lovely chatting to you today.
And I'm looking forward to working with you on some of the subcommittees that we're
Excellent.
expanding.
Yes, and we'll fix all of the world's problems, won't we?